Hello, good evening and welcome to another program on Law and Order. Now, you heard of public procurement. Whenever government or there's a procurement related to public reasons, there are 3-4 aspects that come into play. The decision making of what goods to be taken or the service to be taken, the payment method, and also how the procurement was totally done. And you have also heard these procurements come into question a lot of times, especially in the present day. We see a lot of public procurement has been questioned in so many areas. But what exactly is this public procurement law? Are we aware of it? I think most of us are not, because it's a very rarely spoken subject. So tonight we thought we would bring an expert on the area and discuss to educate you on the laws or the legal framework in Sri Lanka relating to public procurement. My guest today is no stranger to Rupavahini. It's Sabrina Yusuf Ali. She is a specialist in this area of law and an attorney herself, and as well as a researcher. Sabrina, thank you very much for coming in.
Thank you for having me.
Always a pleasure, and welcome back, I would say. You were here once again about a year before, and thank you for accepting a very rare area. But I will start with the question, which obviously would everybody want to know. What is, before we go to the law, what is public procurement?
So I think that's a really good question, because before we go into unpacking this area, I think it's important that we understand really the amount of things that we're talking about when we talk about public procurement. When I first started studying the area, I associated public procurement with your big ticket construction or your procurement relating to aircrafts or essentially big ticket construction items. But then when you actually unpack it, you see that public procurement is really everything that the government buys. So obviously it includes your big ticket items, but it also includes things like pens, papers, chairs. So really, when you understand the scale of things that are being bought by government, it's not surprising then to believe that public procurement, that the government in 2015 spent almost 600 billion rupees on public procurement. Right. And in that context, that's a pretty large sum of money that essentially is taxpayers' money. So we really need to be asking the question, is public procurement as efficient as it could be? And if it's not, then how are we going to solve it?
Okay. You mentioned a word called big ticket. What is that?
Essentially, big ticket means expensive items. So items that would typically cost a lot. So construction typically costs a lot. Building a road typically costs a lot. And when you talk about public procurement, you associate public procurement with those kind of big spend items. Not really on the things that relatively go unnoticed, like the procurement of pens and paper, for example, by government.
Now, Sri Lanka is a welfare country compared to most of the countries. We have free medicine, free schools, and all that. So obviously the public procurement is more in Sri Lanka.
Yes.
Am I correct? Now, what is the framework or the guidelines on this in Sri Lanka? Where does it stem and how does it come?
So actually, interestingly, Sri Lanka has no public procurement law. How public procurement is regulated in Sri Lanka is through public procurement guidelines and a public procurement manual. So the manual essentially sets out the processes that a government authority is required to follow before it procures items. Now, obviously, this is a problem here, because violating these guidelines don't have a specific procurement-related offence in law. So from an enforcement point of view, that becomes a little concerning. But maybe let's take a step back and talk about what are the issues that arise in the context of public procurement. So I think that in the context of public procurement being almost a 600 billion rupee industry, and it's an industry essentially supported by taxpayer money, we should be asking the question, as to how it can be made more efficient and what are the current problems that exist in it. So the way we've kind of identified it is there are 3 big issues that we can spot with public procurement. The first issue is the lack of information surrounding public procurement. So, for example, if I ran a business and I wanted to find out the relevant tender notices that were coming out in relation to my business, so if I ran a paper company and I wanted to know all the tender notices that the government was putting out in relation to paper procurement, I would have to really hire someone to sit down and look through all of the newspapers every day to find out the relevant tender for me, right? So information is costly, information is hard to find. Then there are also issues with regard to the tender notice that is published being changed last minute before the bid is actually awarded. Now that's an issue because if I have spent weeks and months preparing a bid that is now irrelevant, that's a huge cost to me that can easily be solved by good information. Then the other issue is that if in the event procurement contracts are awarded on a flimsy basis, there is really no way to challenge it because as a bidder, successful bids are not published. Sometimes you don't even know who has won the bid. So again, these information issues are really the stumbling block with regards to the efficiency of procurement.
Okay. The Right to Information Act, which you and I did a program on this show, has it helped? Now this on getting, I'm diverting a little from the topic, getting information for somebody to bid on the public procurement. Has it helped so far?
So actually it's too early to tell whether it has helped or not. I can't comment on that. But you certainly can use the Right to Information Act to file requests pertaining to information, say, on successful awards. Now, the Right to Information Act may not be as useful if you are a supplier and you want to know the tender notices that are coming up. Because the Right to Information takes about a month for you to actually get the information in your hand. By that point, it's probably too late because the bid would have been kind of put up and awarded by that point. So it's not really giving you quick access to information in that sense, which is why information is still going to be a problem, notwithstanding the Right to Information Act. And even on look at it from the government point of view, there really is no mechanism where, say, for example, a supplier gives you really faulty products. There is no way to blacklist that supplier across government. So today I say, this supplier is horrible, it's given me faulty products. Tomorrow another government ministry can procure from the same supplier. So there should be a way that the government knows that certain suppliers should be blacklisted on the basis of past track records. There is no way to keep that information within government right now. Then, so information, first problem. Second problem is that there are very high transaction costs involved in public procurement, attributed to the fact that the process is cumbersome, and it's also very, very time consuming because it's manual. So someone in government was telling me that sometimes it takes almost 3 months to procure a pen. So that really is inexcusable when you're demanding more efficiency from government. Also on the side of the private sector or suppliers, every time you want to ask a simple clarificatory question from a government ministry, you have to trek all the way to the ministry to find out this particular problem. You have to trek to the ministry to file your bid documents, to get more clarification, to get more information. And that's, again, a huge cost in terms of both time and people. So high transaction costs. The third a significant issue, and this is kind of the issue that gains the most kind of media attention, is the fact that you have a significant amount of unchecked anti-competitive practices or corrupt practices that occur in public procurement. So I'll pick out two kind of areas that I see that are a problem in this context. Firstly is unsolicited bids. Unsolicited bids, what an unsolicited bid is that usually when you a competitive bid is when you and 5 other bidders bid to government, and then the government will decide, okay, who's the bidder that's best on price, who's the bidder that satisfies our technical requirements most efficiently. An unsolicited bid is when a government points to a specific party without any competition involved and say, look, I will procure from you. Now, what is the problem there? The problem there is that the moment you arbitrarily decide that you're going to procure from someone without putting it into a competitive process, you're automatically agreeing to purchase things at the price that person says that they will give you the goods for. Right. So say, for example, in a competitive bidding process, you can procure your item for 100 rupees. In an unsolicited bid, competition isn't at play. You could potentially be procuring that good at 1,000 rupees without an assessment as to who is going to satisfy your technical requirement the most. And actually, this is a huge problem because it ends up costing the public more. And an interesting study was done in the context of highway procurement, and it was found that procurement in the highway industry between, I think, 2012 and 2014 meant that you were overpriced at something like 135%. So that's almost a 200 billion loss to government. So huge issue, unsolicited bids. The second issue is the fact that actually challenging procurement awards are quite difficult because obviously, firstly, there's no law, and secondly, there's no independent kind of complaints mechanism that comes into play. So let me take an example of, when you have purchasing of a relatively high value, the cabinet gets involved, and there's usually a cabinet appointed selection committee that assesses the bid. So huge construction projects, for example, would be assessed by a cabinet appointed selection committee. So if you have an issue as another bidder, if you have an issue with who got the particular product, how the project, how it was awarded, your only option is to complain to the Procurement Appeals Board. Now that Procurement Appeals Board is appointed by Cabinet, is accountable to Cabinet, and reports its findings to Cabinet. So now in the event you have pointed out a conflict of interest that has resulted in the award of this particular bid, who is the ultimate arbiter on that? Cabinet. So your only recourse then is to go to Supreme Court, which is an extremely lengthy and costly exercise. So really there is no independence.
Supreme Court appeal from the
Procurement Appeals Board. So that would take a significant amount of time, and a lot of companies wouldn't be willing to spend the time and money it takes to engage in this. So really the lack of independence in kind of scrutinizing procurement, I see is that it is a huge issue, not only an issue from an anti-corruption standpoint, but also an issue from the fact that it ends up costing the public more. So those are kind of the three issues.
You mentioned, if I were to recap, three important points: information problem, and transaction problem, and the bidding problem. Okay, now before we go to the appeals and the correction needed, existing guidelines. You said there is some guideline. Where did they stem from? There is no act, you said, there is no law.
No, so the
How are those guidelines made?
Yeah, so the Treasury essentially published those guidelines, I think in 2005. And right now it's administered by the Public Finance Department under the Ministry of Finance. So I know the National Procurement Commission under the 19th Amendment has been appointed in 2015, and their task is really to come up with a national procurement law that would capture all of these essentially gaps that we have identified.
Right. Now, in those guidelines, you said there is an appeal board, right? Now, and then there is appeal from appeal board to Supreme Court. Isn't this process, and you mentioned these people who are being appointed to that is also done by the same cabinet or whatever. If this is not satisfactory, let's go to other countries' examples later. What would be the best mechanism?
So right now, I think that if there is a complaint relating to procurement, that complaint should really be filed at the National Procurement Commission. In the same way that we do right to information, we challenge the government on not giving us a right to information request, we go to the Right to Information Commission. It's an independently appointed commission. It certainly has far more credibility than a cabinet appointed commission. So I think that in this situation, complaints regarding procurement should be lodged at the National Procurement Commission.
So there's a legal issue there.
There is a legal issue there, yes.
Okay. Now, what are the laws or the guidelines in other countries if you are in your research?
So actually, I want to take a step back. And if we're talking about public procurement or solving issues in public procurement, we can we can look at two solutions. One is a solution in plugging the law, right? So to make sure that your law is really tight, that it covers all of the issues that we've spoken about with regard to public procurement. The second kind of way of solving this is to look at the system. So ultimately, my view is that ultimately we care about the system.
Yes.
Sri Lanka is really good at passing laws,
Yes.
not so much as fixing the system. So to take a very pragmatic point of view, my entire efforts are going to be channeled at ensuring that this system works. A law is helpful, yes, but it's not the only tool that we have at our disposal.
So when you say system, to put the system right, what do you expect?
So actually, just looking at other countries is helpful.
Okay.
E-procurement or electronic procurement is something that has been floated for a number of years across a number of countries, including countries in South Asia. So for example, electronic procurement is practiced in Bangladesh, in India, in Nepal, in countries like Afghanistan and Vietnam. So it's really
not very developed countries either.
Yes,
yeah.
it's not a new phenomenon, and it really doesn't depend on you being a Western country that's well adapted to technology. So essentially, very simply, what an electronic procurement system will do, and the government has spoken about its interest in actually rolling this out. So this is not coming from the sky, as it were. Essentially, what an electronic procurement system can do is that it centralizes the entire bidding process from end to end. So from the point of view of publishing tender notices to the point of view of award, an electronic procurement system can support. So an electronic procurement system, or EGP, because it's a tongue twister, an EGP system can help you publish your tender notices, can help the government evaluate its bids, and can publish a successful award. So this is something that has been done very successfully, in many countries, and it really helps solve the information problem, because all of your tender notices are published, they're searchable by category, they're searchable by value. In the event the tender notice is changed, the suppliers get notified. So it really solves the information problem. It could solve the anti-competition or the corruption problem, because everything is transparent. Right. So I think it's a really good and attractive solution, because it solves some of the key issues that exist in public procurement right now.
Right. Now, coming back to my question, which we've given a very good technical answer of technical solutions, but laws. Have you seen better laws and guidelines in other countries?
Yes,
and
absolutely.
if so, which country?
So Japan has really good guidelines. South Korea has really good guidelines.
What are those? What are the? Give me some examples of nuance of those guidelines.
So actually, they have an offence. So the idea that you have to have an independent assessment, that's something that's very strong. And two, it's also because countries like South Korea, for example, they really don't depend so much on their procurement guidelines, because again, their system does the work for them. So now in South Korea, after the electronic procurement system, South Korea is able to process its bids in 2 hours.
Right. Okay.
Right. In Mexico, after it introduced its electronic procurement system, some journalists got onto this system and tried to find out, because there was an allegation about corruption in the president's office. So some journalists got onto this platform and tried to figure out, where this money was going, on what was money being spent on, and they found out that the president in Mexico at the time was spending $500 on a monogrammed towel. So the idea that the system actually unlocks efficiency is something that's quite important to recognize. In Bangladesh, after the introduction of electronic procurement, I mean, it was doing procurement in 51 days before the institution of EGP. After EGP, Bangladesh is now procuring at 29 days. So it represents.
So what are the? Sorry.
So there's a huge value proposition.
Right. What are the laws that emanate from? Is it just the same kind of a guideline that like we have devolved from financial divisions or something, or is there a separate stringent law enacted for that?
So there's
Japan,
a separate. You can do a national procurement law. So essentially what happens now is that procurement, because it's a guideline, in the provincial council you have flexibility to deviate from these guidelines when it suits you, right?
That has to be gotten out of.
If you have a national procurement law, it would cover all kinds of procurement.
Right.
And this is something that countries have done. If I look at Sri Lanka's procurement guidelines and flag another issue, so if I'm looking at in the context of moving towards electronic procurement, one issue is the fact that actually the issue isn't the fact that we can't disclose our tender notices on the web. Right now the procurement guidelines allow us to disclose any amount of information, or government to disclose any amount of information on the web. Right, so tender notices potentially can be disclosed on the web, no issue. So the first step essentially of electronic procurement, which is having a centralized platform where you can have all of your documents online, is possible. The other issue that might run into a bit of trouble is the fact that the guidelines prohibit the electronic submission of bids. So if you want to move to a
Sri Lankan guidelines.
Yes. So if you want to move to a EGP system, a number of countries have actually amended this in their law and made explicit provision for the electronic submission, evaluation and award of bids. So this is something that countries have taken on board very seriously, but again, a lot of countries have taken the system and then worked back in terms of the law.
Right. Yeah. Now, with all these developed countries doing it and half-developed countries doing it, and you said Japan and Korea has like most of the other things near perfect system. But aren't there any issues that have come up in public procurement in those countries?
Of course.
Yeah.
I mean, you're never going to be able to eliminate issues completely.
Yeah.
So the only thing that we can hope for is that even if we make the public procurement marketplace 1% more efficient, even if we manage to save 1% of earnings in public procurement, we're looking at a savings of almost 6 billion rupees.
Right.
So I'm not saying that this EGP system solves everything.
Yeah.
It certainly makes it better.
Yeah. What are the problems those countries face? Any country?
So the problems with electronic procurement, especially in countries like Bangladesh and India, is it requires a technology rollout. So you have to make sure that the staff in your ministries are trained, that they're not intimidated by computers, that they frequently upload this documentation, and that they so essentially training is a big challenge, and that has to be provided for. The second thing is you need a strong body that is actually able to monitor these particular procurement, that is able to monitor and oversee public procurement, but is also able to hear complaints relating to public procurement. So right now, we have a National Procurement Commission. You need to arm it with enough staff to actually receive and process complaints. It can't be just 3 people sitting in a room. So that's something that other countries have, the issues that other countries have faced. And the third thing is that you can't actually eliminate unsolicited bids. So if you have unsolicited bids, you don't go through the system, you go outside it. So one way to do this is actually to ban unsolicited bids other than in very specific circumstances in a law or a guideline, for example.
Okay. When you have done an unsolicited bid or not followed the procedure, does the law of any country on the public procurement allow you to cancel that situation?
Yes. So for example, if you've done an unsolicited, so if you haven't followed the process, for example, if you've gone to an unsolicited bid without following the process set out in the guidelines, so either the national or the independent commission in that country would challenge it, or a supplier could challenge it. And even if it was found to be erroneously awarded, you can void the contract.
Right. I know we have lots of issues here. I think most of the suggestions you gave will help if people want to improve that. But where you represent Verise or any other organization, haven't they put forward to the government any suggested proposal to sort this out?
So actually we've released a study on electronic procurement about 3 or 4 months ago, and we've discussed this with government at length. And now I've seen actually what's exciting me is that I'm seeing government talk about electronic procurement in a very serious way. For example, the Deputy Minister of Finance, Iran Vikramaratne, did mention at a forum that the government would be very serious about unrolling e-procurement, and I'm looking forward to that.
Right. Sabrina Yusuf Ali, thank you very much for touching upon a very rare area of law and necessary area of development which you all have done. And thank you for doing those researches and trying to develop Sri Lanka law. And thank you for sharing that with us on Law and Order today. Thank you for joining Law and Order. Right, that's Law and Order for today. You can join Law and Order on our Facebook website, that is Law and Order Sri Lanka /Facebook, or the reverse, Facebook /Law and Order Channel I, That is Facebook/Law and Order Channel I. That's the way you should check it, and not the other way around. And join our conversations there. And you can go to our YouTube channel, also Law and Order, and look at our past shows as well. I'll join you next week at the same time with another program on Law and Order. And enjoy the rest of the program on Channel I. Have a nice weekend. Good night.